So friends, Trump flunky Lindsay Halligan just got her butt handed to her by a federal judge. And the James Comey prosecution, the Comey case, is hanging by a thread. And even that single thread is fraying. Let's talk about that, because justice matters.
All right, everybody, welcome to another episode of the Prosecutors Verdict. You know my friend Kevin Flynn, 35-year federal prosecutor at the DC US Attorney's Office. Together, we try to bring to bear our 65 years of prosecutorial experience on the legal issues of the day in a recurring segment that we call the Prosecutors Verdict. So, Kevin, thanks for jumping on with us again and helping us unravel, the continued insanity in the James Comey case.
Great to be here as always.
So let me just set up what this motion is, and then I'm going to throw it to you to talk about what the magistrate judge said and found. There are a whole bunch of motions that have been filed in the James Comey case, and they have kind of been split up into several different batches. So this motion that we're going to talk about today has to do with what Lindsay Halligan said and did in the grand jury, the evidence she presented to the grand jury, and whether any of it was so problematic, so improper, that the normal grand jury secrecy rules should yield, and everything that happened before the grand jury should be given to James Comey and his defense attorneys to make a motion to try to dismiss the case based on misconduct and prejudice before the grand jury. So that was what this motion was limited to. Now, tomorrow, I will tell everybody, I'll be in court, federal court in Alexandria, Virginia, because the vindictive prosecution and selective prosecution motions will be argued tomorrow morning in court in the Comey case. And then there is a third motions hearing set down the road with some other motions to be litigated. So we're just going to deal today with the motion regarding what Lindsay Halligan did before the grand jury and how the magistrate judge ruled. So, Kevin, against that backdrop, can you tell the folks a little bit about what we saw in this ruling by Magistrate Judge William Fitzpatrick?
Yeah, it really is extraordinary, Glenn. The fact is that this is the sort of opinion that you see released by, say, a bar counsel in a disciplinary proceeding for an attorney. The ethical lapses of the type that the court is taking pains to observe occurred in this case they're rarely, if ever, the subject of a judicial order that's issued by the court. And very elaborately and in very detailed fashion, the judge lays out a series of findings toward the end of the opinion, and each of them goes directly to the heart of improprieties that appear to have been committed in the grand jury by the prosecutor, who, by the way, I will mention again, as you and I have talked about, was not a practicing criminal lawyer before being appointed the U.S. attorney, and that's another whole issue, and had never been in a grand jury, and therefore had no training in being in a grand jury, and predictably, lapses happen. Now, mistakes in the grand jury are one thing, ethical violations are quite another, and constitutional violations are still of another order of magnitude. So what the judge pointed out, I think we can batch these the findings into a couple of different categories. Number one, the judge found that the government came into possession of materials that had been that were attorney-client privileged. And without getting into a whole lot of detail here, the government routinely comes into possession in the course of an investigation of communications between a client, that being the defendant, and their attorney. And there are steps that are taken by every legitimate and ethical prosecutor to make sure that the investigating side of a particular case is not privy to privileged communications between a defendant and their client, which it's common knowledge that those communications are privileged. They're sacred. Their confidentiality is sacrosanct.
And Kevin, let me just add, one of the ways we might come into it is if we, get search warrants or we issue grand jury subpoenas, and let's say we get some recorded voice messages or communications between the defendant and his lawyer. We have, processes in place where we can make sure we are shielded from it, and that information is never presented to the grand jury because it is, quote, incompetent evidence before the grand jury. You can't present protected attorney-client communications to a grand jury, even if they happen to be wildly incriminating. So against that backdrop, keep going, please.
Sure. And this judge, having ordered the prosecution to turn over not just the witness transcripts, but all of the proceedings that happened before the grand jury in this case, knows exactly what was presented and how. And to play on your example there, I think a good analogy or a good example would be, say you have a case where the government has evidence that a defendant has been communicating with people on the outside by way of, say, let's just say written letters to do crimes on the outside, maybe intimidate a witness, maybe kill a witness or whatever. Probable cause would then exist for the government to obtain a search warrant from a judge to go into the defendant's cell, and the terminology of the warrant would be such as where the scope would be all written materials within the jail cell of the defendant. So that search is going to yield generally a lot of writings. So the investigating prosecutor can't just delve into that big stack of materials. There is what's called a filter team that comes in, and they are not part of the investigation, and they filter through all of the written materials that have been procured by the search warrant, and they separate out anything that on its face appears to be attorney-client privileged, with that term not being narrowly applied. In other words, anything that could be attorney-client privileged is separated out. It doesn't go to the investigating team. The investigating team doesn't even see it. And in fact, the filter team then turns that back over to the defense counsel for the defendant. And so that's the procedure in place. Here it appears from and the court has found a reasonable probability that this happened, that the investigating team was all up into this material and not only used it for its own investigative purposes, which would have been verboten, but also presented it to the grand jury as if it was competent evidence. So that is a massive transgression, the likes of which I've never seen before. And as you've already observed, you haven't seen it before either.
So that's one batch of wrongdoing by Lindsay Halligan and the FBI agent. Now, let's remind everybody, she presented only one witness to the grand jury, the FBI agent. And the way this opinion reads, the evidence seems to have been awash in potential attorney-client privileged information. And the way the judge's opinion reads, it's like they just didn't even care. They didn't care to put it through a taint team or a filter team to protect the sanctity of the attorney-client privilege. They're just like, let's just throw it in front of the grand jury. But because it is deemed incompetent evidence, and let me just add, if people don't know, in the grand jury, there are no rules of evidence. The rules are very lax with respect to what we can present. Do you know we can even present to the grand jury evidence that we believe might have been seized by the police, by the FBI, in violation of the defendant's Fourth Amendment right against an unreasonable search and seizure? We have policies that say we shouldn't, but it's not a constitutional violation. But the things that are sacrosanct are things like attorney-client privilege or doctor-patient privilege. Those are incompetent evidence. And if prosecutors sort of negligently, recklessly, or cavalierly, intentionally put that stuff before a grand jury, that could result in the indictment just being flat out tossed out by the judge, dismissed, including with prejudice, which means it could never be rebrought. So it may not sound as egregious as it really is when we're explaining it, but this is bad. I mean, this is really bad conduct by a prosecutor. It's insulting to call Lindsay Halligan a prosecutor, insulting to all actual prosecutors, that is. But this is bad. But that's the first category of wrongdoing that the judge lays out in the opinion. What's the other?
I don't actually know. I don't know if I put a number on the batches. I'm thinking of more even as we speak. But a second is it's axiomatic that a prosecutor who goes into a grand jury presents their case and asks the grand jury to vote yes or no on an indictment based exclusively on the record before the grand jury. And so that record can consist of, as you observed, various types of evidence, including hearsay evidence. But the record is the record, and a prosecutor can't ask the grand jury to vote on an indictment on anything other than the facts that have been presented to the grand jury. Here, this judge, after having reviewed the minutes, in other words, what the prosecutor, not only the witnesses that the prosecutor put forth before the grand jury, but also what the prosecutor argued to the grand jury, the judge has found that the prosecutor, at one point in presenting this case to the grand jury, said that the government has a lot more evidence that they're not presenting to you, and you can consider that in deciding whether or not to vote out this indictment. And that is, I mean, it's hard to really weigh. Any one of these violations, and there were numerous, would be enough to taint this indictment to the point of dismissal. It also would be enough to have the prosecutor referred to appropriate bodies for disciplinary proceedings. But in conglomeration, it's a travesty. It really is amazing, and I don't use that word like that lightly. As 35 years in the job, it's a difficult job. It is very challenging, and mistakes can be made. But in this case, like you say, it appears that this particular prosecutor was just hell-bent to get this indictment through as quickly as possible with as little record evidence as possible. And we know why, because there was a statute of limitations impending only a couple of days following the return of this indictment. And the attorney general who appointed Lindsay Halligan was under orders by President Trump to get this case through and to indict it.
And so let's talk about the next batch or category of improper evidence that was presented to the grand jury. And this one involves a defendant's absolute Fifth Amendment constitutional right to remain silent against self-incrimination. So talk to us about that one a little bit.
Sure. It's one of the things which is really energizing about a grand jury practice is that unlike when a prosecutor is before a trial jury, grand jurors can ask questions. Now, there are limitations. Trial jurors can ask written questions in some courtrooms through the judge, and then they can be acted on. But in a grand jury, the grand jurors can be quite active, and they're asking you questions as they are asking witnesses questions, aside from the questions that the prosecutor poses, and they can also ask the prosecutor questions about what the laws are that are being under which the case is being charged, or certain other issues having to do with the case. And we as prosecutors serve as the legal advisors to the grand jury. So with that having been said, this record shows that a grand juror asked the prosecutor something about the case, and certain parts of this opinion include redactions. But Lindsay Halligan's response was, there we go. Lindsay Halligan's response was, well, Mr. Comey can testify to that at trial. So here's what we're talking about here. Number one, Mr. Comey, like any other defendant, has a complete Fifth Amendment right against self-incrimination. Nobody can make him testify, and nobody at trial can comment on the fact that he or any other defendant has chosen not to testify. The other thing about this, which is insidious, is that even though the prosecutor did not say this in so many words, that statement was tantamount to saying Mr. Comey could also come in here and explain to you and answer the question that you have, and he hasn't chosen to do so. She doesn't say that, but it's pretty implicit. Once you start trampling on a defendant's Fifth Amendment rights by referring to the fact that he should have an obligation to testify at trial about the particular issue that was the subject of the question. Once you've gone down that road, you've basically gone down the road of also impinging upon his right not to testify before a grand jury.
And let me explain in kind of an everyday circumstance, so people will understand how the Fifth Amendment can be the third rail. If you touch it in court before a jury, you could buy yourself a mistrial like that. And here is how I would explain it. Let's assume a run-of-the-mill violent crime case in D.C. We get enough evidence to secure an arrest warrant for the perpetrator. We arrest the perpetrator. Perpetrator's taken down to the police station, given his Miranda rights. And Miranda rights, your right to remain silent, your right to a lawyer. And the arrestee says, I invoke my rights. I don't want to make a statement. I want a lawyer. He's invoking his Fifth Amendment rights to silence and counsel. Now, imagine if we walked into court, we indicted him, we had a trial date, and in our closing argument, and let's assume the defendant didn't testify at trial, as is his right. If I made the following closing argument, there would be hell to pay. If I said, ladies and gentlemen, you heard when the defendant got arrested, what did he do? Did he say, I didn't do it? Did he say, I have an alibi? No. He didn't make any statement at all, did he? He decided he wanted to remain silent. He decided he wanted a lawyer. What did I just do? I used the defendant's invocation of a constitutional right against him, and I asked the jury to draw an inference of guilt by commenting on his invocation of his right to silence. That's an instant mistrial. That may be a dismissal with prejudice, so the case could never be rebrought, and it would certainly get me referred to bar counsel, investigated, and probably disbarred. In fact, when a defendant chooses not to testify in trial, you know what the judge instructs the jury? Ladies and gentlemen of the jury, this defendant, like every defendant in a criminal case, has an absolute right to testify at trial and an absolute right not to testify. And you may not hold against him his decision not to testify. You can draw no inference from his exercise of that constitutional right. Do you understand? It's sacrosanct. It's the third rail. You don't touch it. And not only did they touch it, they really didn't seem to give a rat's ass, or Lindsay Halligan didn't know enough to keep, her big mouth shut when it came to James Comey's ability to testify or decline to testify. So that is another, it's just so outrageous to career prosecutors to see somebody go into the grand jury and engage in this kind of behavior. So with that, are there other major missteps that you want to touch on, Kevin?
Well, there's the entire mystery gap in the recordings of the proceedings, which the judge has appropriately noted, because the judge obviously has gone through with a fine tooth comb the materials that were provided to him upon demand. Those materials being the minutes of the grand jury proceedings. The fact that the judge in the first place felt compelled to order the prosecution to turn over those minutes strongly indicates that there was a suspicion, even before those minutes being turned over, of potential abuse of the grand jury. I, in all of my years, never had a judge demand that I turn over the minutes of the grand jury proceedings. And just so that your audience knows, the minutes consist of not witness interviews, grand jury interviews, which are transcribed and generally are turned over to the defense as to the witnesses who are going to be testifying at trial. The minutes include anything that the prosecutor says. And from the time that you walk into a grand jury and the door closes, either the prosecutor, the court reporter, or the foreperson of the grand jury says, we're on the record. And everything in that room is on the record from then on. There is a tape recording of witness interviews, but also a written transcript is prepared. There are also recordings of every single detail that happens in a grand jury, all the way up to the point where the grand jury indicates that they are ready to have a vote. And at that point, the door is closed, there is no court reporter, and the grand jury deliberations remain secret. But here, what happened was, and the judge has noted this, that there is a gap in the record, in the recordings from a certain time. I believe it's 4:28 p.m. on the day that the indictment was returned, up until a considerable time afterwards. When pressed on this, the prosecutor said, well, that was only during the time that the grand jury was deliberating. Well, the problem with that is that the judge in this order establishes a timeline. And without getting into the weeds too much, the timeline completely undermines the contention that it was only grand jury deliberations that were unrecorded. And the judge basically doesn't really come right out now and say this, but the strong implication is that the representation that was made to the judge that these recordings consisted of grand jury deliberations only was not accurate. And if that's the case, this prosecutor would be accused of and appropriately referred to bar counsel, for example, for lying to the court. And there is nothing that is more compelling than the obligation that a prosecutor has to be candid with the court. And the term candor with the court, it goes way beyond outright lies. It goes toward not concealing facts from the court if the court asks questions about them, for example. It goes into a whole array of ways that a prosecutor needs to and has to be upfront with the court in any representation that the prosecutor makes. And here it appears from this order and the timeline that the judge has established that rule was flouted and was thrown out the window by this prosecutor as well.
So we'll sum that block up by saying, oh, Lordy, there might be missing tapes. We're going to hear more about that, I think, in the near future. So before we talk about what our verdict is, what kind of a verdict we want to render, I just want to read two short passages from Judge Fitzpatrick's findings. First of all, he says that the prosecutor, Lindsay Halligan, made a, quote, fundamental and highly prejudicial misstatement of law. That's with respect to the Fifth Amendment, the right to silence. A fundamental and highly prejudicial misstatement of law that suggests to the grand jury that Mr. Comey does not have a Fifth Amendment right not to testify at trial. The prosecutor's statement ignores the foundational rule of law that if Mr. Comey exercised his right not to testify, the jury could draw no negative inference from that decision. And then I want to go right to the judge's conclusion, where he writes that the FBI agent who testified and the prosecutor, Lindsay Halligan, engaged in, quote, a disturbing pattern of profound investigative missteps that led an FBI agent and the prosecutor, Halligan, to potentially undermine the integrity of the grand jury proceeding. And with that, the judge ruled, yes, there's an adequate showing of misconduct before the grand jury, such that the ordinary rule that says, no, the defense doesn't get everything that happened before the grand jury, including the audio recordings of every word the prosecutor said, that rule yields to the finding of misconduct before the grand jury. So that's the ruling the judge made. And now the magistrate judge hands it back to Judge Nachmanoff, who is the presiding judge, and he will ultimately decide what the consequences are up to and including perhaps dismissing the indictment. Of course, we still have the other legal issue kicking around that has been litigated, and we're expecting a ruling any day now from Judge Curry. That has to do with whether Lindsay Halligan was unlawfully appointed in the first place, so she shouldn't have been permitted to step foot in the grand jury. That would be another basis to dismiss. Then tomorrow we have the vindictive and selective prosecutions. Again, there are so many potentially case-ending motions out there that, I know what my verdict is. The verdict that I have fashioned is that Lindsay Halligan, insurance lawyer turned failed prosecutor, engaged in what I believe is disbarable misconduct. And I think I would enter special findings that the Comey case is now hanging by a single thread, and even that thread is fraying. So that would kind of be the way I would sum up what we've seen here.
Yeah, my verdict, and this is going to be a little bit wordy, but just in terms of the ultimate outcome, is my verdict, meaning my instinct, where I think this is going, is that the government, I would not be surprised if the government moves to dismiss this case at some point in the near future, as opposed to having all of this egregiousness, even more egregiousness, be put out there. I think that then the outcome is going to shift, because I would expect that Mr. Comey and his lawyers would move for that to be with prejudice, such that the government couldn't bring this case back. And then that will air out even more of this, because the government would likely oppose that. Anyway, very, very long-winded verdict. I guess I'll come up with something better. My verdict is this prosecution is a disgrace to our profession.
Yeah. And we'll be back in court tomorrow, and we'll see what the litigation on the vindictive prosecution and selective prosecution issues look like. I'll be jumping on Substack to give you the blow-by-blow as soon as that hearing concludes. And of course, I'll be with you all tonight, probably at 8 p.m., maybe 8:30. Stay tuned for our nightly community meeting. So, Kevin, thanks for jumping on again for another episode of the Prosecutor's Verdict. I'm sure we're going to be doing it, again in the coming days.
We have a lot to work with.
A lot of material.
Thanks,
Glenn.
Kev.
Thanks, everybody. I'll see you later.